To this live story now, Bapedi Queen Manyaku Thulare is appealing in the Supreme Court of Appeal in Bloemfontein. This is a decision made by the High Court in Polokwane regarding her ascension to the throne. Some members of the royal family are against the appointment of Queen Mother Manyaku Thulare as a regent following the death of her son, King Victor Thulare. The High Court in Polokwane ruled in favor of some members of the royal family, but the Queen is appealing the decision. The members oppose the Queen, say she's not a rightful regent. Let's listen in.
Aunts, uncles, nephews, nieces, others may not. We don't know. Isn't that the very problem with this case?
Indeed, Justice. Where the court would see it, it's where the appellant expresses her views or its her views in the sense that there is no qualification written elsewhere where it said, I'm relying on the but we rely also, in addition to a version, on the authorities in Kgoshikgolo versus the Commission of Traditional Leadership, where Mlambo said the following. It is charged with and referring to the commission of, the Nhlapho Commission on Traditional Leadership. So then he says in paragraph 37, sub D, where he completely cites what the commission said, that it is tried that in terms of custom, it is rank which determines seniority and not affinity by blood. This is where it comes from, that's
what does that mean?
How does it assist us? How does it assist us?
Indeed. How it assists is if one follows the authorities and the version of the appellant, it accords exactly with that. Even Justice Makho in Limpopo, where the train left the rail, so to speak, was where then the latter part of the definition of where applicable. In a sense, because it says the immediate relatives of the royal ruling, and where applicable, the others.
Yes, but we don't know whether it's applicable or not, which is why we have the very dispute we have in front of us. And the answer just does not appear from the papers.
In the form, if I understand Justice strictly correctly, in the form of independent...
Telling us what custom is. Telling us what the custom is in this community.
Indeed. May I just also ask for clarity, barring what the authorities, all the authorities that we rely on, and barring the commission, because that's where the parties rely heavily on that.
Okay, where does the commission lay this down? I know there's reference at page 473 of the papers, which is the only page that was referred to or relied upon by any, I think by both parties or any of the parties.
That's correct.
They didn't rely on the entire commission. And it starts on page 473 of the record, volume 3. And there's no explanation about this. It suddenly starts in the middle of a sentence on top of the page, 473. That they did not want Sekhukhune III to be king anymore. The Bakomana, then approached the magistrate to withdraw the letter of appointment of Sekhukhune III as King of Bapedi and banish Mankopodi from the royal house. He described the procedure for the nomination of King of Bapedi as follows. So this, to me, isn't the Nhlapho Commission saying this is the way in which a king is determined. It's somebody who approached a magistrate who described it as this. So this is just a record of what somebody said to a magistrate. It's not the commission saying this is the way in which it's done. That's how I read this extract that the parties relied upon.
That's exactly how we read it. But what we think the court should read that also with the authorities of this court in the Hoshikolo that went all the way to the Constitutional Court, that established one principle that says, and it quotes that principle in the Mlambo judgment, exactly from the commission. So in other words, there is a report. The report was tested through cases in court, judgments were made, then it's for, we submit that, then it's for the court to then apply on both sides the versions on the principles that were set out and rule which of the interpretation is the one that accords with the Act, the Framework Leadership Limpopo Act, and accords with the authorities.
So then just list for me, because I don't want to carry on the debate with you, but it would assist me. I'm not sure if it will assist the full panel, but I think it will. So then tell me exactly where in the authority, so we can go back to that at the end of the day. So we've got the Mlambo judgment, and give me the page or paragraph reference again.
This is the paragraph reference. It's Hoshikolo and another. This is the Commission on Traditional Leadership Disputes and Claims 2022 JDR. It's 0781 GP. It's attached to the.
Yes, it is. I just need the actual reference that you gave earlier to the paragraph.
Yes, it's
that you rely on specifically.
Yes, it's part of paragraph 37.
37,
which quotes the Mlapo Commission. So I beg your pardon, Malindi, it's 36. I think in the reported case, 36 comes out on Utah. 36 comes out as 37 for some reason, because what's attached in the papers is paragraph 36. But when one goes to Utah, the 36 is 37, but it makes no difference.
Okay.
So there's a long paragraph that starts citing from the previous judgment of
and what you relied on specifically was that it is status, not blood.
Yes, is the extract from the commission, subparagraph D.
Thank you. And then what else? You said all the line of cases?
Then in the same judgment, we also rely on paragraph 6. And the reason for this reliance is because it gives context to the argument we're making. That
sorry, you said you are relying on what paragraph?
6 of the Mlambo judgment. Also, it's attached in the papers,
Yes.
Yes, but as Justice Kiki said, the reference is the same as 2022 JDR 071 Gauteng. Paragraph 6 says, and the reason why is for illustrative purposes, where the learned judge presidency is occurring. It is also common cause that even though Ryan Thulare and KK Sekhukhune were in effect brothers, and this goes to where we're talking about lineage, and because here we're fighting over seniority, rank, our submission is that suitability is not only by blood. You have to belong to a certain house, there is rank. And I see Justice Spain is frustrated by the submission.
Sorry, you said another paragraph. I don't want to interrupt you because my question is slightly different, because I have read the judgment as it appears in the volume 1, is there another paragraph you want to refer to? Because again, this is the findings of Mlambo JP regarding the papers. But there's not a primary source. There's not an expert that evidence was summarized. He refers to the the whole issue was really about the race judicata and the findings of Van Dijkhoff, J, and whether what weight should be attached thereto. And ultimately, the finding was that the requirement of the judicata was not met because of his horizon.
Yes,
Isn't the source, and this is the question of my colleague Kiki, the source of those customary practices, it's not the authorities. It is experts in the field of customary law, like Professor Mshaku, like many others, who testify about that. And isn't that the way they test their knowledge and their experience by way of questioning them and trial?
Justice Stein, perhaps just to put it clearly, we accept that. We are here on appeal to show that Justice Makova, with respect, was wrong. Part of him being wrong is coming to conclusions in the absence of any of that. So therefore we're illustrating that if one looks at the authorities, looks at what appears, he could not have been correct, especially because the suitability of the candidates, that aspect was not even engaged with. And I'm saying this with respect, moved from that point of trying to characterize, even on the authorities, barring knowing that it's a low bar. The higher bar would be primary evidence read by the courts to reach a conclusion. That we accept. The difficulty is that we have a judgment that says that the first respondent is suitable and has to act. Our case is that the suitable candidate on the facts, subject to proper evidence, is the Queen. That is our case. And for the court of court to have undertaken the exercise without this questioning, what do you mean is the royal family? Appellant, why do you mean that grouping that the court will submit with respect, unfortunately referred to children of the king as a grouping? What do you mean? So the submissions we're making is to explain why the appellant's position, if at all, is the one that makes sense. And the court, if the court did not agree with the appellant, it could not be submitted.
But if there was no, it seems to be that you accept there wasn't really proper evidence before the court.
There wasn't.
So then that would be reason enough, surely, for you to submit that the appeal should be upheld against the order of the court, the High Court.
Indeed.
But then the difficulty is, what about your client's counter-application? Because then which the High Court didn't consider because it granted the main application.
Justice Kitty, that's the reason why we're at pains to show.
Yes.
Even with if I were to state for a moment, for the sake of argument, accepting that the evidence is not sufficient for this court to assess in the circumstances of this case in order to resolve a dispute, and the dispute is no higher than who is suitable. The Queen is suitable.
Well. On what basis are you making that submission that the Queen is suitable? Because that's a function of the royal family to identify. It's not somebody else. It's not the Queen. It's not, but it's the function of the royal family to identify a person. Now, in a situation where it's not clear exactly who constitutes a royal family or members of the royal family, what do we do? Because in this case, it will seem to me that there are two royal families, and the Act is clear, said a royal family, not two. just a royal family. Now, if you've got a dispute as to who exactly or which house constitutes a royal family, which members and which extended family members or close relatives, there's a dispute here. How do we resolve? I think that that's a question that my sister has been trying to debate with you all along. Where we've got this problem about the identity, the constitution of the royal family, because it will seem to me that the royal family performs a very important function. So if now that body that performs an important function cannot agree, what do we do?
Justice only is correct, and that's what's bedeviling this whole process. However, like I said earlier, in the context of an appeal, where there is a judgment that has made findings in a favor, I suppose it kind of reduces the sustainability, if I may say, of the counter-argument, or rather the argument in the counter.
It doesn't reduce it, because the same problem that befell or befalls the main application befalls your client's counter application. It doesn't reduce it, it's exactly the same case. So isn't that the conundrum of this appeal?
It is the conundrum.
So what do we do?
We went to the great lengths to indicate the whole submissions were directed at showing how wrong the judgment is. The bench would notice that as an alternative argument, we said at best all these issues should have been referred to oral evidence and not. But at the end, the appeal should succeed on that basis, because there was no evidence on which the court found to arrive at the conclusion that it has. The suitability aspect, the contrasting the two parties, was an illustration of the exercise that the court should have taken. And if one were to choose the one side, our submission is that the Queen, in terms of rank, using those, or rather applying those principles, would have been the suitable party, that the court, even if the court was wrong, that should have been the outcome of the court identifying.
But it's not just a question of choice, it's a question of where does the evidence stand. And what my colleagues are pointing out to you is that in respect of both the application and the counter-application, there simply isn't enough evidence to identify what custom and what the words applicable actually mean for the purposes of determining who can be constituted as the royal family for the purposes of making this important decision. So even if you're right in respect of the application, the same problem infects the counter-application. So aren't we just back to the proposition that the real question is that the court below, faced with this problem, should have looked to the usual remedies?
Live in the courts there for you, where Bapedi Queen Manyaku Thulare is appealing in the Supreme Court of Appeal in Bloemfontein, a decision made by the High Court in Polokwane regarding her ascension to the throne. Now, right now, we did hear there was a bit of an exchange unfolding between the justices as well as the legal representatives, lots of back and forth over the interpretation of customary law versus constitutional principles. Now, the bench is also pressing the side hard on whether the previous decision fully considered the evolving nature of traditional leadership in modern South Africa. And also, just one of the justices has also questioned whether gender should be a factor at all in determining rightful leadership under the Constitution. And these disputes, while familial, have national significance, and they touch on the broader issue of how South Africa balances traditional governance with constitutional mandates. And we continue to keep an eye on that for you.